Your Excellency, the President of the Republic of Fiji, our President, the Excellencies who are present here from the different heads of missions, the High Commissions, of course the Deputy Commissioner of FICAC, the heads of the different government agencies, the Honorable Acting Chief Justice also. Obviously I don't go to many functions where you are there too, sir. And the independent bodies that are represented here, including the DPP, the Supervisor of Elections Office, Fijian Elections Office, Auditor General's Office, the Fiji Competition Consumer Commission, all the other heads of the different organizations. Your Excellency, with your permission, if I could ask all of us to maintain 1 minute's silence, please, because only a few weeks ago, a very key member of FICAC, who is the chief investigator, Sireli Tangidaki, passed away, and I believe taken too early. He's still quite young. But he was a man of a lot of integrity. So if we could just honor that just for a minute's silence, please. Thank you. Your Excellency, ladies and gentlemen, corruption is quite simply the theft of our people's future. It undermines their belief that they can achieve their ambition through hard work and honest means. Even worse, corruption breeds more corruption. Human beings generally adapt to their environment. When they learn at a young age that they cannot advance through honest hard work, when they see personal connections and bribery rewarded over merit, when their ambitions are dashed because they played by the rules and others didn't, they often adapt for the worse. They unwillingly become corrupt out of necessity, sometimes so gradually that they do not realize that they have changed. That insidious, systemic culture of corruption is the worst disease a society can have, because it favors privilege over inclusive progress, halting a nation's advancement in its tracks. It is the duty of governments and multilateral institutions to recognize corruption as the economic, social, and political disease that it is, and to root it out in all of its ugly forms. Your Excellency, ladies and gentlemen, I'd like to thank the United Nations Pacific Regional Anti-Corruption Project and the Fiji Independent Commission Against Corruption for organizing the launch of the anti-bribery campaign. The Fijian government, of course, in its commitment to uprooting systemic corruption, established anti-corruption legislation and institutions well before ratifying the United Nations Convention Against Corruption, or UNCAC. At an institutional level, FICAC was established under the FICAC Act in 2007. Fiji also established the Prevention of Bribery Act in the same year before ratifying UNCAC in 2008. As a person, when I worked in the private sector, I was a board member of Transparency International before 2007. And I remember on a number of occasions approaching the previous governments to ratify UNCAC, but they refused to do so. The principles and standards established under UNCAC have been woven into the very fabric of the Fijian Constitution. Section 115, subsection 7 of the Fijian Constitution ensures that in the exercise of its powers, functions, and duties, FICAC must be guided by the standards established under UNCAC. Indeed, even after ratification, we made sure that Fiji put itself up for the peer review program. So we had countries coming into Fiji to peer review us to see how we were complying with the provision of the convention. And indeed, Fiji then was asked subsequently to go and peer review other countries. Fiji's constitutional recognition of UNCAC is actually unique. Under the Constitution, FICAC is also given both institutional and administrative independence and places an obligation on Parliament to ensure that FICAC has adequate resources to effectively fulfill its mandate. It does not recognize political affiliation, it does not recognize privilege, it is an impartial and independent agent against corruption. The Fijian Constitution is one of the world's most progressive. In addition to civil and political rights, it promises an array of socio-economic rights which are also enforceable against the state. And now, of course, as you know, there's a vertical and horizontal application of rights in Fiji. In other words, it can also be applied against private actors in the state. These include the right to economic participation, transportation, food, water and sanitation, access to housing, health, education, and access to environmental rights. Essentially, they mandate that governments strive for an inclusive economy, one where well-being is a priority for all people, not simply those who can afford it. These mandates actually are corroded by corruption most of all. When we hear that someone has lied, cheated, or taken a bribe behind closed doors, or commits what we call a white-collar crime, it may not make our blood boil, as it might if we witness a crime that's committed on the streets here in Suva. But actually it should. Corruption is not a victimless crime. When a society tolerates corrupt actions and bribery, it permits an unequal playing field. It cripples economic advancement. It protects socioeconomic, civil, and political privilege, and economic privilege. It keeps the disadvantaged disadvantaged. It cements the vulnerable on the margins of society. It destroys the public's trust in institutions, and it is a direct assault on the safety, the aspirations, and the well-being of ordinary Fijians. For example, just some very obvious examples. If a government official takes a bribe to ignore a requirement of a manufacturer to obtain a license to carry out proper inspection of food items, that unregulated product then goes into the market. It may be cheaper than other food products, which are produced in line with the regulations. That bad food is then consumed by members of the public, unsuspecting members of the public, and immediately, or maybe over a course of years, their health is affected. They may die earlier than they probably would or should. We see clearly that how easily corruption, in fact, directly, literally and figuratively, can do and kill people. If we have a healthcare system where we may be buying lots of equipment, X-ray machines, MRIs, etc., supplies, medicines, if there is corruption, if there is bribery, and someone has embezzled funds, then maybe the equipment won't work. Maybe the MRI machine won't actually work, won't give the right image. So the doctor's ability to diagnose will actually be limited. Could be the wrong diagnosis. Worse still, as we have seen in the past, we spend huge amounts of money when there's corruption. So you could probably buy a machine for $1 million, you may end up spending $5 million. So that $4 million could have probably helped build somebody's home, put a seawall, maybe put some solar energy, maybe go towards social welfare. But we are then being deprived of access to that finance because somebody along the line has made money. The same goes for protection of our environment. The same goes for public housing. The same goes for education, transportation, water and sanitation. Corrupt practices endanger rights that are critical for our people's well-being. These, in fact, are not luxuries. These are basic human rights. You cannot live a full life without them. In fact, the deprivation of these rights can place people's very lives at risk, as I mentioned. Both blue and white-collar crime must be treated equally and seriously by all those entrusted with enforcing the law. I remember a few years ago when I was at the DPP's office, there's one particular, I had a case before the courts. A gentleman had stolen about $50,000 over a period of time, so stole from his employer. And I remember that same time, there was a case in Tavuni where a young man had stolen the flip-flops of a tourist from a hotel. The magistrate gave the sentence of 18 months to the gentleman who stole the flip-flops because he said he wanted it as a deterrence because tourism is important to us. We don't want unsuspecting tourists to think that Fiji is not a safe destination to travel to. And the gentleman who stole $50,000 was negotiating on a 2-year sentence. It is therefore imperative that courts consider how these rights are impacted when deciding on matters of corruption. They must consider how the state's resources are affected. They must consider what could have been had that corruption not taken place. But what they must not consider is equally important. The reality is that these so-called white-collar crimes too often take place at the upper end of the socioeconomic spectrum. It can be the wealthy, the privileged, the entitled, the senior civil servants, and even the elected who are corrupted. And when those cases come before the courts, a person's status should not signal leniency. It does not matter who they are. It does not matter who their parents are or may have been. It does not matter what job they hold, what businesses they run, or what title have been bestowed upon them. Corruption is corruption. In fact, as these crimes rise to the higher levels of society, so should and indeed do the stakes. The damage can be even more greater, because if a leader, a CEO, or someone with proximity to power is corrupt and gets away with it, people take note. It is a signal to them that those actions actually condone. It erodes trust in the system. It encourages others to do it. Say, if this guy can get away with it, I'm only taking $1,000. I might as well do it too. And it squanders the promise of the Fijian constitution, which His Excellency, our President, actually talked about. There can be no untouchables in the Fijian society. The culture of corruption must be combated at every level. Lawmakers alone cannot win that battle. FICAC alone cannot win it. If we are to build a culture of fairness and deterrence when it comes to corruption, we need the judiciary squarely on the side of a corruption-free Fiji. So the question of this morning must be, what side will our courts choose? Will they avoid taking on the issue of systemic corruption and all its insidious complexity? Will our system reward status with leniency and put minor legal technicalities that can be corrected and is not material ahead of the public interest? Does the obligation to uphold the constitutional rights of our people end at the halls of government buildings? No. It extends to the courts, and we need the courts fully enlisted in Fiji's quest to root out corruption, root out inequality, and punish all those who break our laws. Right now, the record reflects otherwise. There are many cases in Fiji where the courts have interpreted anti-corruption laws narrowly, with no regard as to how corruption impedes the realization of socio-economic and other human rights. For example, we had a case where the registrar of a university and also the manager of various other schools was charged with abuse of office and general dishonesty. He allegedly used over $100,000 with the free education grant by government intended for the primary school, and he managed it as a loan to other schools. The court, however, found that a breach of a regulation or directive alone is not necessarily tantamount to dishonesty or to a criminal offense, and the accused was actually acquitted. Unfortunately, the court did not take into account the fact that the primary school was not able to recover all of that loaned money. Some went missing. Dollars that will never go to the benefit of Fijian students. Resources that could have applied towards their education and their future, as those dollars are the sort that pay dividends back for generations by building a more educated Fijian workforce. And that is what we must consider. Our children's welfare should be considered. The stolen future actually should be considered. And this matter is currently being appealed by FICAC. Cases like these raise questions about what side our courts have chosen. What substantive justice is not delivered? Socioeconomic disparities are reinforced, and the fight against systemic corruption suffers for it. The FICAC Act 2007 and the Prevention of Bribery Act 2007 act as a bedrock that provides a strong legal foundation in Fiji's fight against corruption. The legal framework established by these laws in Fiji are not something new. They have been successfully tested and applied in places like Hong Kong since the 1970s, in fact, where we got the impetus for FICAC. Unlike Fiji, the development in Hong Kong's anti-corruption jurisprudence has seen the courts taking a proactive and modern approach in broadly interpreting the application of Hong Kong's anti-corruption laws in the fight against systemic corruption. The Hong Kong courts have developed various legal principles when interpreting the anti-corruption legislation, in particular the anti-bribery laws. One of those principles developed through the Hong Kong jurisprudence is known as the general Sweetener principle. Under this principle, there is no need to prove a quid pro quo for the civil servant who receives a benefit to constitute a bribery offense. Even without any favor in return, if a civil servant accepts a gift merely as a token of appreciation, it is still tantamount to bribery. These types of gifts are given to civil servants simply to keep one in the good books of the civil servant without expecting any immediate favor in return. But that is the very beginning of corruption. This is how it starts with a simple gift to win the heart of the civil servant, although nothing is expected immediately. And of course, there's always competing interests. In fact, I remember at one point in time in the judiciary in Fiji, it was a practice that law firms were allowed, or in fact the judiciary accepted Christmas gifts. Now, if this side of the room are all lawyers, and they all give Christmas gifts, but these lawyers choose not to, who will the judiciary smile upon when they appear before them in the courts? Another principle that has been developed through the Hong Kong jurisprudence is known as the capacity test. The prosecution must show the benefit received by the civil servant directly to how he or she benefits by the bribe in his or her official capacity. That is, would that gift have been given, or could it have been effectively solicited if the person in question were not the kind of public servant he or she in fact was? These principles have also been upheld in the English courts. Ironically, whilst the Fijian courts have not stopped themselves from applying various principles of law developed in the common law jurisdictions, say from UK, etc., in other areas of the law, but they seem to have not applied the same jurisprudence that is actually developed in UK and Hong Kong, stopped in applying those when it comes to corruption. Applying those legal principles will assist in the development of anti-corruption jurisprudence in Fiji and provide added impetus in the fight against corruption. Unfortunately, in fact, in some cases the courts have outrightly denied applying these common law principles, and of course some of these matters are before the Court of Appeal. Your Excellency, ladies and gentlemen, it is imperative that in building strong and accountable institutions, we must have a robust legislative framework which accurately reflects corrupt behavior. To this end, in 2009, Fiji repealed its penal code and passed the Crimes Act, which redefined offences of corruption. These offences include bribery of public officials with a very broad definition of who is a public official, a reversal in the burden of proof in relation to one of the fault elements of the offence, and a special provision that custom and tradition are not permitted to be defences to the offences of bribery. Under the old criminal law regime, the penal code, which we inherited from UK through Queensland and British India, the penalty available for serious offences such as abuse of office was minimal and was not commensurate with the seriousness of the offence. For example, if I use Faikek versus Kenin Dakun Raketi case, the accused was charged for various acts of abuse of office amounting to approximately Fijian $5 million. The accused was charged under the penal code, and the court could only sentence him consecutively to a maximum of 6 years, because the maximum punishment for abuse of office under the penal code was only 3 years. However serious the offence was. This, of course, has been rectified under the Crimes Act 2009, and now the maximum punishment of the court can impose, is 17 years, approximately a six-fold increase in the punishment. This is important to effectively deter like-minded offences. Recently, in the matter of Faikek versus William Katia case, the High Court had imposed a 23-year-long punishment for a scam involving Fijian $4.1 million. The Court of Appeal has also reaffirmed the sentence imposed by the High Court. Now this brings me to another question. The independent bodies must also be doing their work. We must be able to prevent bribery. So it's very difficult to understand how this particular scam that went on for years was actually not picked up by the Auditor General's office. When if you look at it, it's actually quite simple. So independent bodies like the Auditor General's office need to focus on basic work of audit work, and that is looking at the facts and figures as opposed to some of the other things that they may be doing at the moment. Given the importance of corruption cases, the judiciary should strongly consider establishing a separate branch, and we've had discussions with the Honourable Acting Chief Justice, a separate branch that looks exclusively at corruption-related cases, as in the current practice with employment and family matters. Many jurisdictions around the world are considering specialized anti-corruption courts. One example is Indonesia and its corruption crimes court known as Tipikor courts, which exclusively hear cases from its Corruption Eradication Commission. In the interest of these cases being dealt with decisively and expeditiously, Fiji should consider the same. We recognize that constitutional and legislative changes on their own will not remove all our challenges in our fight against corruption and in building strong and independent institutions. Thus, we recognize the need for society-wide shift in attitudes that is carried forward through training and education through multi-sectorial partnerships, including in our primary schools. We hope this badge with the slogan, "I don't accept bribes," I'm actually not wearing them at the moment, supposed to be, that's why I've got this badge, sends a very clear message to every level of Fijian society. Public officers and indeed civil servants are the backbone of good governance. Your integrity and the integrity of your office must never be compromised at any stage. We hope through this campaign we are able to bring awareness of anti-corruption measures, address systemic corruption in the public sector, and encourage members of the public to come forward and report incidents of corruption. Indeed, this is why we are seeing more of this happening. In the same way, domestic violence has existed in Fiji for a very long period of time. But when there was no enabling framework, legal framework to help and give people the confidence, the victims of domestic violence, to come forward, nobody did. So you see a spike in the cases that are being reported. It gives people the comfort and the solace. Similarly, we must ensure that we continue to have that particular energy and drive towards bribery, or stopping bribery, stopping corruption. And in particular now, when you have a pandemic, when you have people not having access to jobs, etc., people can become desperate, and those in positions of power can take advantage of their desperation. So this is why we should become even more vigilant in these times. Once again, I wish to thank His Excellency, the President of the Republic of Fiji. Thank you, Your Excellency, for coming to this event, because it gives it that mana, that level of importance that we are placing on anti-bribery measures. I wish to also thank the UNDP and the UN Pacific Region Anti-Corruption Project for their crucial support and partnership in Fiji's fight against corruption. Thank you very much.